Well, this is kind of important, I believe, because we have a political agenda being used to present scientific, erroneous scientific data as fact, and then not permitting true science, or at least some way of having courts decide between two sets of data or whatever. A lot of these cases come down to expecting a court to make decisions of, as to what set of scientific data is true or not. So that to me is when the Chevron decision involved and the Daubert principle is involved. That at least should open the door to a more judicious way of deciding or allowing true science in to make decisions.
Well, it will open the door. It will govern the operations of the trial court. That is, principles like the Daubert principle in terms of what it is that they're willing to admit and call it good science. The appellate courts, however, are not going to get involved in that area. The appellate courts are going to read the statutes and they're going to read the Constitution and they're going to try to apply the words, the text of those statutes. Some judges look to other things like purpose, history, structure, etc. But they will try to apply those as legal principles that govern the outcome of the case. They will rely upon the facts that are developed either by the legislature or in testimony before trial courts. Once the appellate court takes hold, the fact finding is pretty much, with rare exceptions, pretty much finished. Now, I will say this. Let's take an example of a case. Actually, it happens to be a gun case that took place last year involving bump stocks. So the case was Garland versus Cargill. The court decided that a bump stock doesn't qualify as a weapon. When I quote from the National Firearms Act, that fires automatically more than one shot by a single function of the trigger. So during the Trump administration in 2017, ATF reversed its long held position and held that these bump stocks are equivalent to machine guns. But then the Fifth Circuit stepped in and they disagreed. So the Supremes were asked to intervene. And Clarence Thomas, again writing for the conservative bloc, 6 justices, held that the bump stock ban exceeded ATF's statutory authority. Bump stocks, said Thomas, increase the gun's speed, but not automatically by a single function of the trigger. So the important point here, back to what we were discussing just a moment ago, is not that the appellate court, the Supreme Court, defined what a bump stock was. It's rather that the Supreme Court determined whether or not this bump stock qualified under the statutory definition of what a bump stock was. So the Supreme Court doesn't rewrite the statute. It applies the existing statute. And if Congress gets it wrong, the court's not going to do much about it. If they come up with the wrong decision, if they say something is the equivalent of a machine gun, when in fact most of us would think it is not, then the court is forced to apply a statute that in fact may be based upon bad science. The court's not going to correct the science. The court will, at the trial level, admit good science or reject bad science. But once it gets to the appellate court, the court is simply going to apply what the statute says.